do for a living, Miss Thomas?
Well, I guess you could say I'm a car dealer, so I used to work at Peaches. But the place was really shady, and then I wanted some upward movement, so I got a job at the Black Bear Casino.
What is working at the Black Bear like?
I really like working at the Black Bear. The job is a very good one, and the people I deal with, they seem to be a lot more honest, like a lot more honest than the people I deal with at Peaches. It wasn't as shady, and then my boss, Avery Bancroft, he's the kind of boss I want to be working for, because when I work in Black Bear, I get paid on time, and I see all the legal permits hanging up in the casino. It's a very good place to be.
What else did you notice about the Black Bear that was different from Peaches?
Other than all the people and the kind of job that I do, I also noticed that, because it's a casino, you have to notice about the security. So in the Black Bear, the security is a lot tighter than it was at Peaches. At Peaches, people got paid under the table and a lot of shady things went on. But in the Black Bear, there were security cameras everywhere, and you could be sure that if you're in the Black Bear, you're being watched at all times.
All right, now what does your job at the Black Bear entail specifically?
Because I'm considered one of the more experienced dealers, so I work mostly in the VIP room. I deal blackjack, I deal poker, something like that.
What kind of people come into the VIP room?
Mostly politicians and celebrities. I see Governor Walton, and I've seen Miss Covington in the VIP room.
What was Miss Covington like when she was in the VIP room?
Well, I see her gamble. At first, she seemed to lose a lot of money, and it just seemed like she didn't have a mind for it. But at other times, she did win. It just wasn't as often.
Do you remember any times when Miss Covington won a lot of money?
I do, actually. And I would say maybe it was a huge haul, because the whole table was like cheering for her and everything, patting her on the back. And the other players at the table seemed very upset about it. I would have to say it was on April the 6th.
Miss Thomas, when was the next time you saw Miss Covington at the Black Bear?
The next time was April 16th. I think it was around 2 in the afternoon. So Miss Covington came in and carrying a briefcase, and Mr. Bancroft also came in carrying a briefcase. They sat on my blackjack table, and I got cards to them.
What did they do with the briefcases?
When they came in, they just left it beside their own chairs. So yeah.
How long were they there?
It wasn't very long. They played for a while. They seemed pretty distracted. It was a work day after all, so they came in their suits. I don't think they had much time, And then after a while, they left.
Miss Thomas, while you were dealing cards to Mr. Bancroft and Miss Covington, did you see them switch their briefcases at all?
No, I was dealing cards, trying to pay attention to my job. I wasn't paying much attention to others. And it was a table. It wasn't transparent on anything. I couldn't see under it. I didn't see a switch of briefcases. If they had switched anything, I would imagine it would be kind of awkward trying to move around in the suits. So no.
Did you see any money change hands between Mr. Bancroft and Miss Covington on April 16th?
No, I did not.
Did you ever see your boss accept money from Miss Covington? Or, excuse me, see Miss Covington accept money from your boss?
I did not.
Thank you, Miss Thomas. I have no further questions.
You sure? You've seen the defendant on many occasions in the VIP room of the casino, correct?
Yes, I've seen a lot of politicians and celebrities.
But this particular politician you've seen lose huge amounts of money in this casino, correct?
Yes, everyone in the casino loses huge amounts of money. That's how we as a casino make money, and how I think why my boss is such a good boss, because that's how we make money.
You've actually seen her lose $1,000 in a single hand of blackjack.
Objection, Your Honor, relevance as to the dollar amounts of how much Miss Covington is losing.
By going on about how much money she's losing at the casino, it will lay further foundation to whether how much money she is going through and why she would need to get bribed $200,000.
Your Honor, if I may, we've already established that Ms. Covington lost money. The specific dollar amounts don't make any fact in this case more or less likely. In addition, delving into why Ms. Covington would need to be bribed is improper.
I'm going to overrule the objection.
Yes, Your Honor.
I'm sorry, could you repeat the question?
Sure. Again, you've seen her lose $1,000 in one hand.
Yes, most of the people who come and play lose quite a huge amount of money. It wasn't uncommon.
In fact, you've seen her lose $100,000 in one day.
Yes, that's what happens in the VIP room.
Let's move to April 16th. In the Black Bear Casino around 2 p.m., you saw Avery Bancroft, your boss, come in and sit down at your table, correct?
Yes, my boss came in carrying a briefcase.
She was sitting directly across from you, correct?
My boss? Yes, he was sitting across.
And then, roughly 20 minutes later, the defendant came in and sat to your left.
Yes, Ms. Covington came in also carrying a briefcase.
So, you've never seen a briefcase, have you?
No, I found it kind of odd that they would bring briefcases in, but you know, it was a business day, they were in suits, I figured.
You've never seen your boss or anyone have a briefcase on anywhere on the casino floor or the VIP room ever before.
That is correct.
And then another 20 minutes passed. Another regular came and sat down to the far right of you at the poker table, correct?
Yes, Casey Catton.
And while you were getting this new regular ready, Covington left.
Yes.
You weren't paying much attention to Covington, were you?
No, I wasn't. I was paying attention to
Thank
giving
you.
cards and doing my job.
Your Honor, I ask that my witness be allowed to finish answering the question.
Allow the witness to finish
I
her.
apologize.
So yes, like I said, I was paying attention to doing my job, so I didn't notice exactly what she was doing when she left. I know that she picked up the briefcase and left.
So, you can't be sure whether or not they came in and left with the same briefcase.
I can't be sure, but you know, like I said, if there had been a switch of briefcases, it would have been really awkward under the table, reaching very far in.
Miss Thomas, I find it hard to believe while you were not paying attention to Covington, you would notice anything weird happen. She is 3-4 seats away from you at the table when you were turned to get the new regular ready. How are you sure you didn't see anything awkward?
Because it's kind of far also, if you reach under, I would notice like, you know, this kind of movements and I would see. So it would be, like I would be able to notice it in a sense.
In fact, actually, in your own words, it does make sense that they did switch.
Because I had never seen people bring it in, but I would say it's possible, but I didn't see any switch.
So yes, you said, so you think they did make the switch.
I say it's possible that they made a switch, but I didn't see any switch.
This is your testimony here in court today.
I'm sorry?
This is your testimony here in court today.
What is?
So you think it's possible it happened?
Yes.
Your Honor, may I approach opposing counsel?
What lines would you be referring to?
I'll be referring to lines 162 to 163. May I approach the witness?
You may.
Is that your name at the top of that document?
Yes.
Is that your signature at the end of the document?
Yes.
Are you aware that you had up in 24 hours before trial today to make any relevant changes to your affidavit?
Yes.
Can you read lines 160, go to lines 162 to 163? As I read aloud. the end of line 162, it says, "It does make sense they did switch."
Yes, that is correct.
Objection, Your Honor, hearsay. No direct contradiction has been elicited to what the witness testified to. Therefore, this impeachment is improper and does constitute hearsay. The witness said that it made sense, that it was possible. And opposing counsel asked her, so you think they did switch? No direct contradiction has been elicited as to from what she said and what's in the affidavit.
What would be the contradiction, counsel?
She said it's possible to happen, but in her affidavit, she had a positive stance as to whether or not they did make the switch in front of at her table.
How so?
She said that they did. She says, so it does make sense that they did switch.
Your Honor, if I may, it says it does make sense. That doesn't mean that she has a positive stance. She's saying it's possible. Maybe they did switch, maybe they didn't. She's not saying they switched.
I'm not seeing the contradiction here, so I'm gonna sustain the objection.
Motion to strike that impeachment, Your Honor.
Motion granted.
So you were focused on getting the new player ready.
Objection to asked and answered.
I was done asking the question. She immediately answered. I was just more of a pause, and that was the point I was going to actually ask her.
I'm gonna allow counsel to reestablish himself.
Yes, Your Honor.
So as you were focused on getting the new player ready, you cannot be certain that the defendant left with her briefcase.
You're done with the question?
Yes.
Okay. So, I was paying attention to my job. I can't be certain of anything, but like I said, I don't see an explicit switch.
The defendant and Avery Bancroft are sitting right next to each other. So is it possible that maybe when she reached down, she grabbed another briefcase? It's not that far to reach. They're right next to each other.
Objection, Your Honor. Opposing counsel is testifying for the witness.
I was
I'm
asking,
gonna overrule that objection.
I'm sorry, could you repeat the question?
so it is possible, seeing as they're right next to each other, that when she reached down to grab the briefcase, she did not grab her own.
It is possible what she did, I would never know, but I did see her do the long switch.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your May I proceed? Ms. Thomas, you were just asked about how Miss Covington lost a lot of money at the casino. Did she ever win?
Yes. I believe it was on April 6th. I think she won a huge haul because everyone came around congratulating her and she seemed really happy and everyone else seemed upset.
Had you seen her win before that?
Yes, definitely. I mean, when you come to the casino and play, it is natural to lose a lot, but you also win.
Thank you, Ms. Thomas. No further questions.
You wanna recross?
I have no recross, Your Honor.
This witness may step down.
Your Honor, the defense calls Miss Lori into the stand. Before we begin this direct examination, may I prepare the well for a demonstrative?
You may.
Thank
You may.
you.
Allow it.
May I proceed?
Okay.
Can you please introduce yourself to the court?
Good morning, Your Honors. My name is Jessica Danielle Lorian.
What do you do?
Currently, I am the owner and chief auditor of Gaylord Strategies. I work with local and state police departments on the proper procedures and protocols of police investigations, including undercover operations.
Can you please tell the court about your education?
I have a Bachelor of Science in Applied Mathematics and Statistics from Johns Hopkins University. I have my Juris Doctorate from University of Virginia School of Law, as well as my Master of Laws from Harvard Law School.
Are you published in your field?
Yes, I have 15 law-reviewed articles on subjects ranging from inducement of informants to entrapment. Along with this, I have co-authored 2 peer-reviewed articles on cognitive biases in forensic analysis with colleagues who are forensic psychologists.
Before working for Gaylord Strategies, what did you do?
For 25 years prior, I was a part of the FBI in the White-Collar Crime Division. I partook in hundreds of undercover operations. And focusing on the White-Collar Crime Division, I didn't really deal with the CEOs. I did more of the fun ones, the drug rings, the money laundering, all the ones that you see on HBO.
Miss Lorian, why are you here today?
I was asked to analyze the procedures used by the Midland State Police Department, particularly the ones that led to the arrest of Avery Bancroft and Chase Covington.
So, you're being paid?
Yes, I'm being paid $30,000, which is standard in my field, to look at the undercover operation and techniques conducted by undercover officer Mickey Keenan, which led to the arrests of Avery Bancroft and Chase Covington. And then I was also hired to relay all the information I found in my report.
For your analysis, did you have sufficient facts and data?
Yes, I FOIA'd the Midland State Police Department, which means I filed a Freedom of Information Act to get access to all public records. Because prior to that, none of these records were willingly given to me. But after I FOIA'd the MSPD, they gave me everything they said they had.
Did you review anything else?
Yes, I also received the affidavits of Officer Keenan and Corey Hyde, as well as all the email correspondence between Corey Hyde, Mickey Keenan, Avery Bancroft, and Chase Covington.
Did you use reliable principles and methods for your analysis of the Midland State Police Department?
Yes, I used the Attorney General's undercover guidelines.
What do these guidelines do?
These guidelines keep officers safe and protect innocent parties. Anytime a guideline is violated, there are negative consequences.
And did you reliably apply these principles and methods to the facts of today's case?
Yes, I was a part of the development and later the implementation of these guidelines, so I always apply them to every case.
Miss Lorian, have you ever dealt with the Midland State Police Department before?
Yes, back in 2014, I performed an audit of the MSPD, and later this audit was printed in its entirety by the BNN.
What was the purpose of this audit?
Mainly, we were looking to make sure that the MSPD was following all the proper guidelines and procedures in undercover operations they were conducting.
And what were the results?
Of the 40 undercover operations conducted between 2010 and 2014, 70% of those violated the guidelines. 50% of those had not contacted the prosecutor's office, and 5 did not have the proper authorization.
I'd like to talk about the specifics, but first to clarify, what are undercover operations?
Undercover operations are essentially a police investigation where an officer is undercover. There's 2 different classifications for undercover operations, a UCO1 and a UCO2. Today's case had all of the elements of a UCO1.
What are the elements of a UCO1?
A UCO1 has a proprietary business, in this case Avery Bancroft's Black Bear Casino, or an elected or appointed official, in this case Chase Covington, chair of the Gambling Commission.
And what is the process for a UCO1 proposal to be commissioned?
The proposal must clearly define and describe what the end game is. Then the proposal must be submitted to the prosecutor's office, who determines if the proposal has enough merit to be pursued.
Now, you mentioned several things that must be submitted to the prosecutor's office. Do they need to be documented?
Yes, there's a checklist we follow to keep track of all these documentations, and I've brought this checklist along with me to help give the jury a better visual of everything, if I can use it.
Your Honor, may the witness step down and use a demonstrative?
Any objections?
No, Your Honor.
Now, Ms. Lorien, did you receive these documentations?
No. May I move to be able to?
You may either move or you can move the demonstrative, either,
I can move whenever.
that's fine.
Of all of the files that I received, there was no documentation whatsoever of the procedures used. Along with that, there wasn't even documentation of who the target of the investigation was.
Was there anything else that needed to be documented?
Yes, for the documentation, there are specific guidelines and trainings that each undercover investigator should have, including the graduation from the police academy. That was not documented at all.
Now, did you find any documentation of communication between Officer Keenan with Corey Hyde, Avery Bancroft, or Chase Covington?
No, there was no documentation of any of the conversations or meetings or even phone calls that may have taken place between any of these, which is required by the federal guidelines. Along with this, there wasn't even any documentation that Officer Keenan was properly trained in undercover operations or that he was trained to bring in an undercover informant like Corey Hyde.
Did Officer Keenan follow any proper recruitment of informants?
No, there was no guidelines or
Objection,
even...
Your Honor, to relevance.
Your Honor, Corey Hyde was a large part of Officer Keenan's investigation, and Corey Hyde is a large part in the investigation that we are here today. Whether or not Corey Hyde was properly trained on how to act in this investigation makes a case in this fact extremely more likely.
Your Honor, Mika Keenan's involvement does not make any fact of Chase Covington's accepting a bribe more or less likely. The fact that the informant was informing doesn't go to sway the actions took by Chase Covington.
Your Honor, Corey Hyde testified today that she was part of this undercover investigation. This investigation is what brings us here today, and whether or not Corey Hyde was properly trained in how to handle this investigation and how to act in this investigation calls into question the validity and the reliability of this whole investigation that brings us here today and makes facts in this case extremely more likely and is relevant and admissible testimony in court today.
I'm going to overrule the objection.
Yes, Your Honor.
Yes, Your Honor. Ms. Lorien, did Officer Keenan follow any proper recruitment of informants?
Based on all the documentation I received, I did not find any documentation that Officer Keenan properly recruited Corey Hyde, nor did Officer Keenan give Corey Hyde any guidelines or standards or any kind of background as to how to proceed as an informant.
What else did you look for?
For this case specifically, one of the main documents I was looking for was a document that would establish character traits of the suspects, mainly predisposition, that either one of the suspects had been predisposed to commit the act of bribery. And that documentation, again, was not found in any of the files that I received.
Thank you, Ms. Lorien. Now, something that you just mentioned is predisposition. Can you please explain to the court what predisposition is?
Predisposition is a character trait that an individual would have committed a crime without the presence of an outside instigator. Again, in this case, I found absolutely no documentation that either Avery Bancroft or Chase Covington had been predisposed to commit the act of bribery.
Now, you mentioned some of your concerns before the investigation. Did you have any concerns during the investigation?
Yes, mens rea. It means the guilty mind. In the state of Midlands, it is simply not enough to prove an exchange of money occurred, but they must also prove that the individual had the intent to be, had intended to be bribed and had influenced their act. In this case, there was no documentation that either that Chase Covington intended to be influenced by a bribe.
What are your other concerns with this case?
I also had concerns with cognitive biases with the forensic lab that did the testing of all the physical evidence.
Can you please elaborate on what this means?
main cognitive biases that I think that could have affected the evidence testing is that the lab that did the testing receives a portion of the cost as well as restitution for lab fees for any cases where their technician testifies and a conviction is made.
What about DNA and these biases?
DNA is the closest test that helps to eliminate biases, but it doesn't eliminate it completely. Because DNA can tell us whose fingerprints are there, but they can never tell us how they got there or when. So this only gives us half the picture, leaving the criminalist the opportunity to paint the rest of the picture.
Ms. Lorian, have you reached any conclusions in today's case?
With the lack of documentation of the officer's graduation from the academy, the lack of documentation of conversations, the lack of documentation.
Objection to relevance of the entire testimony. According to the case law, State versus DOSA, the pressure applied to an informant is not the pressure that was applied to the defendant. However, the intentions of a law enforcement officer with an informant may still be relevant to an entrapment defense, and this is not an entrapment defense, Your Honor.
Your Honor, may I ask opposing counsel to repeat which case law he's referring to?
You may.
State versus DOSA,
State versus what, I'm sorry.
DOSA, on the third page.
Your Honor, this case law specifically says that the means by which a law enforcement officer recruited an informant's participation do not in and of themselves support that a defendant was induced into committing a crime. We are not trying to say that only because Corey Hyde was an informant, inducement occurred. We are just getting at the expert's conclusions that she came to, but we are not saying that this is the sole reason that inducement occurred.
Your Honor, the expert's conclusion, it has no relevance to the fact of today's case because this is not an entrapment defense. The defense has not came with an affirmative defense. So this entire testimony is irrelevant to the facts of today's case.
Your Honor, this testimony here today is entirely relevant to the facts of today's case. We are here today because an undercover investigation by Officer Keenan claimed to have found corruption in the Midlands Gambling Commission. This witness here did this analysis of the investigation, and her findings in this case reveal that facts in this case are more or less likely, and her testimony in court today is extremely relevant. However, this case law even continues to say the interactions of a law enforcement officer with an informant may still be relevant.
Your Honor, opposing counsel didn't finish that sentence. However, the interactions of a law enforcement officer with an informant may still be relevant to an entrapment defense, which their defense is not an entrapment defense. And in addition to the fact that Keenan has only been mentioned in this testimony, not in any other testimony that took place before this. Keenan, as well as this testimony, is not relevant to the the relevance of the case today.
What do you say about Keenan's?
Pardon me?
What do you say to his last comment about Keenan not being mentioned thus far?
Your Honor, this witness testified to what she did not find and what undercover guidelines were not followed. These are specific guidelines, UCO 1. These specific guidelines were not followed by Officer Keenan, and that is what the witness is saying today, and that is why this is admissible in court today. And this case law, if referencing only an entrapment defense, is not relevant to this case because we are not here today to argue an entrapment defense.
Since they are not arguing an entrapment defense, this is not relevant to today's case.
Your Honor, I'm not arguing that the witness's testimony is not relevant. I'm arguing that the case law opposing counsel chose to use in this argument is not relevant to today's case or the matter at hand.
The witness was talking about the informant, and therefore, this case law is relevant to prove their irrelevance of their testimony.
Do you have any further, counsel?
Yes, Your Honor. I would like to direct you to case law Davis v. Adams. This case law states that this evidence that the witness has already testified to is not only relevant, but also reliable. This is because we already showed that she used reliable principles and methods, and this only needs to be proved by a preponderance of the evidence, which we have done, because we have proved that it is more likely than not that this is extremely relevant to the case today, because this witness just went through an entire checklist of items that were not followed in Officer Keenan's investigation that should have been followed, and we have proved this is more likely than not by preponderance of the evidence.
Any further, counsel?
May opposing counsel repeat the case law?
Yes, Davis v. Adams on page 6. Additionally, the next case law, Tarrant Readers Association of Midlands versus Merrill Dow, further confirms this. We have gone through all of the credentials of an expert testimony under Rule 702. We have established her credentials that she used reliable principles and methods, sufficient facts and data, and reliably applied these principles and methods to the facts of today's case, for which she has been called to testify on the Midland State Police Department, of which this informant, Corey Hyde, was used as an informant for. Therefore, this testimony is extremely relevant, makes material facts in this case more or less likely, and is admissible in court today.
Your Honor, according to this case law, the witness can be established as an expert witness, which she has been, but that does not mean that what she is saying is relevant to today's case. Your Honor, I believe that opposing counsel is running in circles on this matter, instead of facing the fact that State versus DOSA is what dismisses their witness, Your Honor.
Your Honor, may I respond? State v. DOSA is not applicable to this case today because it references an entrapment defense, which we are not here today for an entrapment defense. So that case law does not apply to the case at hand.
Your Honor, the expert witness's entire testimony was practically based on an entrapment defense. It had nothing to do with Chase Covington.
I'm going to overrule the objection.
Yes, Your Honor.
Yes, Your Honor. Miss Lorian, have you reached any conclusions in today's case?
Well, based on all the lack of documentation that was not taken throughout the duration of the investigation, along with the potential biases from a lab who receives money every time someone is put to jail, there are grave concerns about this investigation from start to finish.
Thank you, Your Honor. I have no further questions.
May I inquire?
Absolutely.
Thank you. Dr. Lorian, is it true that you did not interview anyone that was involved in today's case?
Well, first, I want to clarify that I am not a doctor, but no, I inquired to Chief Kimball about an interview, and my request interview was denied. So I was unable to give an interview with anyone in the Midlands Police Department.
You didn't interview Chase Covington, correct?
No, I did not.
you did not interview Corey Hyde.
Objection, Your Honor, asked and answered. The witness has already said that she did not interview anyone.
Your Honor, the witness answered the question with she did not interview anyone from the police department. So therefore, she did not answer the question in its entirety.
I'm gonna overrule the objection.
Yes, Your Honor.
Is it true that you did not interview Chase Covington,
That is correct. I did not interview Chase Covington.
nor Corey Hyde?
I did not interview Corey Hyde either.
So you did not interview anyone that was relevant in today's case?
I was brought in to testify and analyze the procedures used by the police department. So, interviewing either Corey Hyde or Chase Covington, I did not see fit to do because they were not a part of the police department.
You mentioned on direct examination that you could not find documentation of Mickey Keenan's training, correct?
Yes, that is correct.
But you cannot say with a degree of scientific certainty that he did not receive that training, can you?
I cannot, but if he had received that training, I would assume that the documentation would be there. Like if someone graduates from high school or college, they have their diploma.
You assume, or are you sure that you will be able to find that documentation?
I assume.
Along with Mickey Keenan's training, you also looked at his general background, correct?
Yes, that is correct.
And nowhere in your report did you mention any past history of misconduct on the part of Mickey Keenan.
Correct. There was little to no documentation on Mickey Keenan's background, so of course I wouldn't find any misconduct if there was any.
In your report, you stated that there were concerns about the bribery being induced by Keenan.
Yes, that is correct.
But you cannot say with a degree of scientific certainty that it was, can you?
No, I cannot.
Thank you. I have no further questions, Your Honor.
Redirect.
No redirect, Your Honor, but I ask that the witness may be allowed to step down.
Absolutely.
Thank you, Your Honor.
Counsel?
Your Honor, the defense calls Chase Covington to the stand. May I proceed?
Absolutely.
Could you please introduce yourself to the members of the jury?
Hello, my name is Chase Covington.
What do you do for a living, Ms. Covington?
I am the chairwoman of the Midlands Gambling Commission.
What led you to that position?
Well, I'm a woman of Midlands. I started at a small law firm here in right Midlands. It's called LL&LPC. I later became associate counsel to the State Department of Labor, later became deputy attorney general, and I am now in my current position of the chairwoman of the Midlands Gambling Commission.
So what do you do as the chairwoman of the Gambling Commission?
Well, I review and I issue gambling licenses and proposals. Anything that comes to our commission, we review and we make sure every policy, every plan goes to my colleagues and I.
So then, how does that get you involved in today's case?
Well, it started around, right now I'm being accused of accepting a bribe from Mr. Avery Bancroft because my commission voted for him because he had the best proposal.
Ms. Chase Covington, did you ever accept a bribe from Avery Bancroft in exchange for a second casino license?
Never, no.
Could you tell us how this whole process began?
It started around last year when the Gambling Commission announced that we would be issuing a new license for a casino. And Avery Bancroft had addressed some interest.
Did you know Avery Bancroft prior to this announcement?
Yes, actually we're acquaintances. I know that he owned the Black Bear Casino, which is wildly successful in the state of Midland, as well as she's a decent friend of mine. She actually came over last year for Thanksgiving.
Why'd she come over for Thanksgiving?
Me and Avery, we share a common misfortune. Both of our parents had passed away, and I decided to invite her over.
Objection, Your Honor, relevance.
Your Honor, we're laying foundation as to how this witness knows Avery Bancroft, and if I may proffer, we're going to use this testimony to explain why Ms. Chase Covington had a briefcase on her person that came from Avery Bancroft.
I'm gonna overrule the objection.
Yes, Your Honor.
Would you like me to repeat the question?
Yes.
So, how did you, or how are you and Avery Bancroft friends?
Well, like I said, I know she owned the Black Bear Casino, and it's my job to know the casino owners in the state of Midlands, as well as, like I said, both of our parents had passed, and I had invited her over for Thanksgiving. And when she came over, she also addressed that she was interested in receiving a license for a new casino. So when she came over, she offered some ideas she had.
So, that Thanksgiving, what did she come up with for you?
Let me tell you this, Avery Bancroft is the most detailed and meticulous person I've ever met. She gave me every single plan, every number, every document, and she actually put it in a briefcase and let me keep the briefcase with all the documents in it. Very organized.
Did you end up seeing Avery Bancroft again prior to the casino?
Yes, in the month of April, actually, I've seen her several times throughout a few meetings, as well as just me being in the Black Bear Casino.
And what did you discuss at these various meetings?
Well, we discussed a lot of plans, you know, the size of the casino, hotel rooms, how big things were, how much things would cost, you know, the things that I need to know in order to make this huge decision.
Have you been here for the entirety of the testimony in court today?
Yes, I have.
Do you remember when Corey Hyde came to testify?
Yes, I do.
Do you remember when Corey Hyde said that you had said to Avery Bancroft, "What do you have for me?" Now, what did you mean by that?
Well, I simply asked, what does she have for me? I need the best possible plan. I mean, we only give a casino license one every 10 years. This is a huge decision. This is all on me. I am the chairwoman of the Midlands Gambling Commission. I need to know everything, and she needs to give me the best plan.
Was Avery Bancroft the only one to come up with a proposal for a new casino?
No, she was not. And actually, Miss Shannon Stark issued a proposal.
So then why did you vote for Avery Bancroft's proposal over Miss Shannon Stark's proposal?
Now, Shannon Stark, she had a really good proposal, but I looked at her experience. She had really nothing. She's only a professional poker player. She's never owned any large business, and there was no proof that she could even run this huge plan that she gave me. And Avery Bancroft, she ensured me that every detail and everything would be executed perfectly.
Is that why you granted her a second casino license?
Of course.
So was careful consideration the only thing that led to your decision?
Yes.
There's been a lot of talk about you gambling at the Black Bear Casino. Did you frequent there?
Yes, actually in the month of April, I frequented there a lot. I had some ups and downs, but I ended up being up for the entire month.
Would the money that you won and lost have been reflected in your bank statement, possibly?
Yes, it would.
Your Honor, at this time, may I tender evidence from the bench? And approach the witness with the same.
Yes.
Now, Ms. Covington, what have I just handed you?
You handed me a copy of my bank statement.
Now, is this a fair and accurate copy of the same document?
Yes, it is.
Now, Ms. Covington, I'd like to talk about a sequence of events that were reflected here. Now, what happened on April 1st?
On April 1st, I made a cash withdrawal of $100,000. And I went to the Black Bear Casino that day to gamble, and I ended up losing the whole entire $100,000 on tables.
And then what happened on April 6th?
On April 6th, I decided to test my luck again. I withdrew $50,000 that day. And again, I went to the Black Bear Casino, and I ended up winning $155,000.
Did you end up depositing that money?
Yes, I ended up depositing that money later that day on the 6th.
Now, it shows another withdrawal on April 8th. What happened on that day?
On April 8th, I withdrew $75,000, and I went to go gamble right after work. This is kind of later in the day, and I usually went earlier, and I ended up winning $200,000 that night. I was ecstatic. And since really the banks were closed after I left the casino, I didn't have any time to deposit the money, so I didn't get a chance until about a week or so later.
When did you exactly make that deposit of $200,000?
I made the deposit on April 17th to my bank. That's the only time, the only day I had a chance to even stop at the bank. I barely even had a chance to eat the whole entire week of the vote. So many meetings, so many things to worry about.
Thank you, Ms. Covington. May I retrieve evidence from the
You
witness and retend to the bench?
Yep.
Ms. Covington, at any point, did you accept a bribe from Avery Bancroft in exchange for a second casino license?
I have way too much respect for my job to ever even think about a bribe.
And I have no further questions, Your Honor.
Cross?
Yes, Your Honor. May I inquire?
Of course.
Miss Bancroft, or Miss Covington, you knew Bancroft personally,
Yes, I did.
and you would gamble at Avery Bancroft's casino.
Yes, that was a part of my job, you know, get some exposure as well as I like to gamble.
Okay. Now, you were meeting with Avery Bancroft on April 16th
Correct.
in Avery Bancroft's casino,
That is correct.
in the casino's VIP room.
Yes.
Okay. Now, the vote for the commission took place on April 17th, 1 day later.
Correct.
Your Honor, permission to retrieve evidence tendered to the bench?
You may.
E-bank statement. Permission to approach the witness in turn?
Of course.
And permission to retrieve a reference copy for myself.
Yes. Granted.
Now, you recognize this as your bank statement, correct?
Yes.
And you recognize that, of course, that is your name in the top left-hand corner.
Yes, sir.
Now, on April 17th, you made a deposit for $200,000,
That's correct.
and that left you with a resting bank account of over $335,000.
That's correct.
All right. Your Honor, at this time, I ask that I be allowed to approach opposing counsel with words constructive remarks, plaintiffs, or prosecution.
You may.
Permission to approach the witness in turn.
Granted.
Do you know what I've handed you?
Yes. This is a copy of my financial disclosure form.
And you affirm that it is the form you filled out.
Yes.
It has your name on it,
Yes.
and it accurately reflects all the finances you disclosed to the state.
Yes, it does.
Your Honor, at this time, we move prosecution's forward evidence.
Any objections?
No, Your Honor, this is a public record.
Now, in this record, it states that your yearly salary from the state is $67,000.
That is correct.
Now, it also states you own a home that has a value between $100,000 and $250,000.
That is correct.
Now, on top of that, it also admits that you have a series of debts that add up to over $135,000.
Law school will get to you, that's for sure.
So you're telling this courtroom today that you have a standing bank account of $335,000, and yet you have not paid off your law school debt, your mortgage, or your credit card debt.
No, I had many other matters to attend to.
All right. Thank you. No further questions. Permission to retrieve and tender?
Absolutely. Thank you. Any redirect?
I have no redirect, Your Honor. I simply ask the witness be allowed to sit.